1 year after being sentenced to spend life behind bars for the brutal killing of former Humatak Mayor Daniel Sanchez, defendant Rudy Fegurgur Quinata had his appeals hearing in the Supreme Court of Guam. Defense contends, just as they did at trial, that co-defendant Joyner Scott Sked was the lone killer. Quinata's attorney Peter Santos arguing prosecutors did not have enough evidence and alleging the lower court abused its discretion when it failed to hold a hearing over an apparent jury misconduct.
The deliberations was protracted. It went on for a very long time. And one of the things that we could have gleaned, or the court could have gleaned, had it done the evidentiary hearing, was when exactly in time was that extraneous information introduced. We have in the record that the complaining juror stated that after the information was introduced, then the straw polling decidedly went in the opposite direction, towards guilt. Now, the main point here is that, or one of the things that the court should consider is that if you look at the transcripts and the records, twice the court called the jury foreman in to ask them how they were doing and whether or not anything was going to get them to decide. And twice they said no, there's nothing that the court can do or further instruction, that they were hopelessly locked. And then all of a sudden, on the third time, now it looks like they're going towards one direction. So it leads the big question. That leads the big question: is it when exactly? And if there was an evidentiary hearing, then they could have discerned this.
Prosecuting attorney Marian Woloshock argued the verdict was correct.
Maybe something else will happen with the juror misconduct. But if you go through our evidence, which we listed in detail in our brief, the defendant says there's nothing like, DNA and fingerprints and so on. That's just the nature of this case. Somebody left the victim's body in this climate for several days. So of course, evidence is going to degrade. But there's plenty of circumstantial evidence. The jury could have inferred that there was animosity between the defendant and the victim because, when the defendant first showed up, he appeared to have been in an argument with his girlfriend, so maybe he was in a bad mood. His girlfriend, jumped on the victim and gave him a hug and kiss, so maybe the defendant got jealous at that. The defendant and victim had a conversation and the defendant said something about respect, which comes right after that. Later on, HB, the neighbor, she heard, the defendant saying F you. And then, there was some hearsay that the defendant's girlfriend said that the defendant was punching the victim. And, there was, to that, there was no objection at the trial and it was not brought up on appeal. So that issue is waived. So that's evidence that made it before the jury that they considered. And then the jury could also infer that the defendant and the victim were together when the victim died. One of the witnesses saw the victim drive away with the defendant and his girlfriend. The neighbor saw the three of them under the canopy at the defendant's house.
In April of 2021, Sanchez was stabbed with scissors and bludgeoned with a hammer. His body left in Quinata's residence with the door padlocked. During trial, defense argued Sked alone stabbed and killed the mayor and that Quinata ran away in fear.
There was blood all over the place. The victim's shoe still had the laces tied, which means there was a violent struggle. The inside of the home was in disarray, which means a violent struggle. The defendant locked the victim in the house when he left. He didn't contact 911 or emergency or GPD. And then he had this strange behavior in the days afterward that could be interpreted as consciousness of guilt. He disappeared for several days. He left his phone by the shore where he may have been washing off blood. He was irritated and in a hurry to get emergency money from his niece's husband. He used the victim's last name when he identified himself to someone. He wanted to go to Hagatna, where the jail is. He wanted to turn himself in and be arrested.
Still, Attorney Santos told the justices in the Supreme Court of Guam today that the case should be sent back to the Superior Court.
There's a lot more circumstantial evidence that uh, would negate the high standard of reasonable doubt. The government in its brief was cherry picking the information. There's a lot of things in the record that negate, what the government is asserting. And like, for instance, the government states that the facts suggest an altercation between Quinata and Daniel, which the latter lost. There is evidence of a struggle, yes. There's evidence of a brutal murder, yes. The evidence that they cite Rudy, Mr. Quinata yelling "F you." That could have been him finding what happened and him yelling at Sked. That does not necessarily point to him having an altercation with Mr. Sanchez. Again, all of the information that the government relies on does not rise to pointing that Mr. Quinata did anything in this case. The co-defendant stated, he told on me. He said he wouldn't tell. What does that suggest?
The High Court took the matter under advisement and will issue a decision.